Okay, the webinar has begun.
Well, welcome everyone. It is now 1 o'clock on Wednesday, January 26th. We're commencing with our CSBARS meeting for the first time in 2022. So welcome everyone again to our new year. If we haven't spoke. This time, should we do our roll call, please?
Jay Frickberg,
Present.
Michael Clancy,
Present.
Linda Keller,
Present.
Paul Kramer,
Present.
Greg Murphy,
I'm present.
Jessica Park,
Present.
George Lill.
Present.
We have a quorum.
Thank you. At this time, should we call for our public comment if there is any?
So the first hand is Rebecca Hirsch.
So if you could please admit Rebecca Hirsch for her public comment. Thank you.
Hi, simply to reintroduce myself. I am sitting here on behalf of Dean Juan Manuel Sariñana, and he was unable to attend today, but I always represent the school in these kinds of meetings. Thank you so much for doing this.
Is there any additional public comment?
Raquel or Natalie, could you just announce the instructions if anyone is trying to make public comment, if they're on the call by phone? Could you just say that for the record as well, in case we have anybody joining us by phone?
Yes, so if you're joining by phone, you can raise your hand by pressing *9. Then we'll be able to see the raise hand signal. You can also later lower your hand by the same, pressing *9. At this time, I don't see any additional hands. Chair Frickberg.
Thank you for the public comment that we did receive. Ms. Hirsch will be returned back to the attendees at this time. Our next point is review of the minutes. My understanding is the minutes have been circulated to our membership. Does anyone need additional time to review them? Not hearing any. Do we have a motion to adopt the minutes or any discussion for any corrections to the minutes?
I move to adopt the minutes.
Thank you. Is there a second? It's been moved and seconded. Can we have a roll call as to the adoption of the minutes as submitted?
Okay. Michael Clancy,
Dean Clancy, I think you're muted. Could you say that again for the record, please?
I'm sorry. My vote is aye.
okay. Linda Keller,
Aye.
Paul Kramer,
Aye.
Greg Murphy. I think you might be muted also. Greg Murphy, I think you might be muted.
Aye.
Jessica Park,
Aye.
Greg Lill, or sorry, George Lill.
Aye.
The motion has passed.
Thank you. We can now move on to our staff report. So Ms. Leonard.
Thank you, Chair Frickberg. My topic is the implementation of the new accredited law school rules. They did go into effect as of January 1st, 2022. Accredited law schools will have the next 2 years to come into full compliance. For reference, both the prior rule set and the current rule set, as well as their guidelines, are currently posted on the rules page of the law school website. And if there are any questions, I'd be happy to address. Seeing none, I think we're ready to move on to the next.
Dean Keller has raised her hand.
Yeah, I just had a quick question. I'm just wondering if we had any update for the process regarding joint accreditation under the rules.
We're working on that, and when it is ready, we'll do an announcement to all law schools, both accredited and unaccredited, and also post the materials.
Okay, thanks.
Thank you.
Should I just start on the report on the exam? Okay. So I wanted to kind of go over everything I've been sending, those emails that we're sending to applicants. I know everyone on this call and hopefully many in the attendee pool have also received these emails kind of going over the procedures for the in-person February bar exam. But I just wanted to kind of go over some of them because I think it is helpful to also hear me talk about them and if you have any questions. So to back some of it up in terms of our COVID-19 changes for the in-person bar exam, everyone's coming into the exam site wearing a KN95 or an N95 or double masking with at least one surgical mask. So that's our masking standard. We're having more distance between the applicants, not only at check-in, but they're also going to be in one person per 6-foot table to have that social distancing around them. This is all in the FAQ, so I know a lot of it's repetitive, but I just wanted to kind of set the table. We're also getting the having them provide proof of full vaccination or a negative COVID test. If they have a negative PCR test, it has to be within 48 hours of the start of the exam. Antigen test, it's 24 hours. So a lot of applicants have been writing in kind of asking about figuring that part out, and they need to do their research about where they can get those tests if they are not coming in with proof of entry for vaccination. We are using, and I'm kind of jumping to some of the really new stuff that I've been emailing out. We're using a vendor called Clear, and you might have seen Clear because they also do a lot of like airport screening, but this is a new screening they're doing through Health Pass where applicants will upload their vaccination records and they validate it. And then we can see in real time how many of the applicants have been uploading their vaccination records. And then closer to the exam day, we'll have people upload those who are coming in with negative tests, upload those into the Clear app as well. We've synced the information from the Clear app to the admittance ticket, which tried to make that clear in these emails, and we'll send another email on Friday. So right now, a lot of applicants have been doing exactly what are in the instructions. So they've been uploading their information to the app. It's synced with our database, and on their admittance ticket that we started having applicants have access to as of yesterday, it'll say vaccination status either clear, which means they went into the app and they uploaded their proof of vaccination, or it'll say not clear, which means they haven't done that yet, or they're going to be providing their negative test. So if you have applicants seeing this and not understanding why their ticket says not clear, it's one of those two things. They haven't uploaded and linked to our event with their vaccination status, or they're planning on using a negative COVID test for entry, in which case it will continue to say not clear on the admittance ticket because that has to come so close to the day of the exam. Let me stop. Were there any questions so far about any of what I've gone over with the requirements for vaccination or testing? Okay.
I have a question.
Yes.
Has the state bar begun to consider what kind of circumstances would warrant an off-ramp from the COVID restrictions? That is, what ought to be the standard? How many cases are being reported in California? The usual data. I just wonder if there's any thought to where that's headed. So if there is a standard, what it might be.
What do you mean by off-ramp?
Well, we don't know what's going to happen with COVID over the long term, whether it's going to mutate into a more virulent strain, more lethal strain, or what's going to happen. But I think most people would like to return to the days when it wasn't necessary to have the kind of restrictions we have now.
Mm-hmm.
And I'm just wondering if any thought has been given to what ought to be the metrics for that off ramp. In other words, when the new case data indicates less than X amount of cases in this county or whatever, or even the state, that's when we can go off ramp. I think some consideration ought to be given to that question. Not right now, but I'm just thinking for the future, that might be appropriate thing to start talking about.
Yeah, for right now, we're obviously focused on the 4 weeks from now with the coming exam, but we're looking at the CDC guidance, the state guidance, the local guidance for in-person gatherings, and maybe once all those sorts of agencies have that sort of off ramp, and that will be the conversation here. But right now, we're kind of just a little bit tunnel vision on the February exam and what we're doing to keep all the applicants as safe as possible. Okay, so that's sort of the admittance ticket, the clear, the vaccination or negative test. And then just one other thing that has been happening this week is that everyone who's been approved and is a laptop applicant, which means not a handwriter, they got all the information from ExamSoft yesterday about the mock exam. And it's a lot more simple. It's very simplified versus the remote exam. So they do a mock exam, they download the files, but they're not the same kind of files as you had during the remote exam because they don't have actual live questions in them. They're just sort of the files where they do the answer window at the site. So they got all those instructions from ExamSoft yesterday. We'll be reiterating them in our emails too. But anyone who was approved for the exam would have received information from ExamSoft yesterday about how to kind of, delete your old version of Exemplify, download the new one. So some of the stuff I'm sure you're very used to, especially if you use Exemplify at your law school, but that went out yesterday as well. And I see your hand, George. I just want to mention one other thing that we did since we last met that was different was we did offer applicants a full refund by January 18th if they had any kind of COVID concerns. And so we had that new refund deadline of the 18th. And then anyone who had withdrawn before that, but within, we had kind of do those incremental percentages, 30%, 60%. We ended up making all those people whole as well because we had a policy after they withdrew. So we went back and refunded them the difference. So that was something new that we've done for this administration since we last met. Go ahead, George.
Yeah, a couple questions. What's the policy of anybody who might unfortunately test positive during the exam or would start exhibiting symptoms? Are they, is it stated that, they've got to not come back? And I guess they would, unfortunately, if say they get sick after the first day or get the results, they wouldn't be permitted back in to complete the exam. That's the first question. And the second question, if what you've Audrey outlined for the CBX in February, is that, if it goes well, and I hope it does, what the first year exam administration will look like in June?
Okay, well, let me try to answer your first question first. So the applicants are also going to be receiving this COVID-19 code of conduct, and anyone who had applicants testing not remotely might remember that we've done this the past several administrations for those coming in person. So they will be testing about, like, if they feel sick or if they have symptoms or they are close to someone who's been sick, they will not come to the exam. So if someone feels sick or is having symptoms and then they won't come, and they can also apply for the medical refund of fees if they feel sick or they test positive, and we encourage them definitely not to come to the exam, and they can apply for the refund of fees. The second question about the June first year exam. So we've been administering the first year exam remotely, and the plan is to continue administering the first year exam for June also remotely. So there will be, like there always are, some extenuating circumstances, folks who have issues with taking the remote exam for a variety of reasons where we will offer them testing space, but I don't think we need to do this level of COVID procedure with the vaccination that we're doing here, because we can check the very few people that'll come in person manually.
Well, thanks, Roger. That's actually good news on the first year. But getting back to the folks attending, I mean, and I guess maybe I'm overthinking this, but if they show up and they, and have a high incentive to come, even if they're not feeling 100%, may not look like they're sick, but if they end up getting sick after the first year, then and they come back after the first day, they know they're in violation of these policies. Does that become a moral character issue? I mean, if they later on test positive and didn't follow the procedures and potentially, expose other people in the testing site?
Well, we are having them attest and sign that they will follow those procedures. So I don't know if I can answer the moral character part of it, but we are having them affirmatively attest saying, I will follow these procedures, if this, then this sort of behavior about how they're feeling or how anyone around them is feeling.
Okay, good. No, thanks for confirming that.
Dean Park?
Thank you, Audrey. I just had two questions. So in terms of coverage of what the CSBARS is doing, the emails going out, continue to go out, and they're very helpful. I very much appreciate it before this exam. I just wanted to check, is the information about clear and such included? I think it was, but I just want to confirm. Okay, great.
It is, and there's a whole separate link in there. If you go back to what I sent for the clear instructions, so there's a web page just about using the app itself, because there's been some, I think a lot of applicants open up the email on their laptop or desktop, so they click on the link and it's a mobile link, so then they were like, oh, it's not working. So there's some instruction, make sure it's a mobile app, so you're going to have to click on this link. And also you don't just download the app, you also have to link it to our event code. So all of that, it's in there, not just in the emails, but also on the separate landing page. So yeah, if you go back and have a read through that, and then let me know if you have any questions. It's a lot of information, but we're hoping with all this kind of repetitive sending it out and making lots of positive encouragement, hopefully from all of you as well, that it'll land. And already there's, we have over half of the applicants have been downloading and using the app already. So it's a good sign.
That's great. Going to my second question, let's say we, if we hear from a graduate that, they have concerns with going to the app, or, they basically they want to have a venue to share about checking on their circumstances. I mean, I think there's one email I've received about someone who has had COVID, and so they think there's natural immunity. I'm not asking about the specifics in this call, but more, where's the best way for law school staff to direct students like this? Like they're coming and saying, oh, I want to, hear more or understand my options for my specific set of circumstances. Let's say it's a highly immunocompromised student. Is there kind of a best way to guide them, or reinforce with them, who they should contact to have those circumstances heard?
I think always starting out with our FAQs and the information we've sent out, because we have tried to game out a lot of the scenarios. I think starting with that is great, and then submitting their concerns, their questions to the applicant portal, because that comes to us staff directly. I know me, Natalie, Amy, all of us would personally review and answer a lot of those questions, and obviously a lot of our other staff members at the Office of Admissions are answering those. So I would say that would be the next best course. And you're free always to email me if you have questions too. And hopefully I make that clear every Friday, because the more the news is spread about exactly what we're requiring through all of you on the ground too, it's really helpful.
Great. And is applicant portal better than, let's say, email? Right?
It's very similar to email,
okay,
right? Because they're going directly to their portal. It'll be linked to all their other, case information in our database. I think that's great.
Okay.
And everyone, my sense is everyone's pretty facile at using it by now.
Okay, thank you.
No worries. Dean Frickberg?
I just wanted to echo what Dean Park was mentioning, and definitely thank Ms. Ching. The email in question is on January 21st, last Friday, a little before 3 p.m. So just for best practices on our side, we've been having our registrar send that to all of our recent grads. So it never hurts to over communicate, as I've learned from Ms. Ching. We over communicate. It's the same information, but maybe ours won't go into spam or vice versa. So especially in these times of anxiety, I think over communicating is better for everyone. Thank you.
Thank you. I appreciate it. Thank you for amplifying all these messages. It's very helpful. Any other questions?
In particular, sometimes the feedback we hear is that for some schools, they have the ability to send texts to their alumni that some alumni appreciate. And so if that's a capability you have and it's been helpful for your graduates, this might be a good time to utilize that.
And we're using the same like subject naming convention. They always say countdown. So if people you text them, they fish out the email that says countdown and read it.
And also in the column of planning ahead for your applicants who have signed up for the BARS Strategies and Stories program, the sign up period is closed, but at this point they've received their program and they're advised to complete that program as early as possible in the process. So that might also be an additional reminder that you would give if you have applicants who've signed up from your school.
All right, thank you. And always let me know if you have more questions.
So our next item is our request for applications and reminder of the due date for March 1st. Sonia, would you like to talk a little more about that?
Yes, please. Thank you, Dean Frickberg. So this year, the deadline has already been extended just a bit for all of the committees and commissions at the State Bar. For those that are interested, at the end of this year, Dean Frickberg, Chair Frickberg, and CBE designee Greg Murphy will complete their terms. Thank you for your service. And so there will be 2 spots open on the CSBARS. If you are interested in applying, the application is now posted. If you go to the CSBARS committee page on the website, you'll be able to link to the website and turn that in by the March 1st deadline. I'm sure there aren't any questions from this panel, having already applied and successfully been appointed to the committee. But for those that are watching in the audience or maybe reviewing the tape, we encourage you to apply. The State Bar has been very lucky to receive more applications than spots available. If you have applied in the past and have not yet had the opportunity to serve, we also continue to encourage you to apply again as well. So thank you very much. And if there are any questions, I'd be happy to address them. Or if any of the members have a thought about the process that could help those that are watching out in the audience, feel free to share. Okay, seeing none, shall I turn to the recent developments?
Yes, please. Thank you.
Okay, so just several reminders. This is the time of year when we reach out to the law schools to ask them to verify the posting of their business and profession code 6061.7 disclosures. This is the time that we do it every year. So you'll be getting an email sometime in early February. I'm asking you to confirm the posting, whether or not you've also turned in that material with your annual report. In addition, this year you recently heard from the National LGBTQ+ Bar. There is a special project focused on registered and accredited law schools this year, submitting that group's campus climate survey for the first time to all of you. And so each school should have received a customized link at this point to respond to that survey. And the survey responses are due on February 28th. And if you have any questions, you can contact that organization directly. They are coordinating the survey rather than the State Bar specifically. Let's see. Also, one final reminder, quite a few people, including in this group, have participated in the Office of Access and Inclusion's focus groups on various topics related to law school retention. There is one more focus group taking place on February 1st. That will be a 90-minute focus group. And if your school is interested in sending a representative to that, you can send the name and the email of the representative to lawschoolregulation@calbar.ca.gov. And I do believe that some of the members here in CSBARS have participated in in some of those focus groups. If anyone wanted to make a comment or two about your experience. Dean Park.
Just wanted to say that I am happy our staff got to participate in both the academic and non-academic support discussions. There's some sharing of what different law schools do from different categories there. I think that's very helpful, knowing that we represent a wide diversity. And I appreciate those opportunities to hear more, especially as the Office of Access and Inclusion is going to come up with a best practices document from that. So I just appreciate the chance to be included in these discussions. And I've heard positively back from staff that have gone as well.
Thank you, Dean Park. Dean Leal?
Yeah, hi, thanks. I personally participated in one of the focus groups, and I thought it was well run and provided a very interesting and I think robust discussion among the other. It was one other dean from a registered fixed facility school, and I think staff from a third. And it was good to just to discuss what they were asking questions about, because it led to other issues. They didn't have an answer. I asked them this question, but what's the forward reporting process? So they hopefully will report what they've gathered and the findings that they're going to eventually come up with the committee of bar examiners. Is it going to be an opportunity to share with the committee as a whole?
Yes, we'll be reaching out to them as they put together something more formal. There'll be information using the annual report, retention data that started to be collected in an expanded format this year, the law school survey that started all of this from Access and Inclusion, and then the information from these focus groups.
Well, can I share with everybody, because I think this was perhaps the most helpful point that we finally got to after an hour plus discussion, because it was all about retention, and they had these graphs showing the difference in retention between ABA, CALs, and registered schools. And it occurred to the deans, myself included, there's one data point data that they should really collect, because I think it has a fundamental and profound impact on retention, and that is getting a survey done as to the percentage of students at ABA schools, CALs, and our schools that self-finance their education. And because I think my overwhelming understanding is particularly my students 100% finance. No one has access to student loans. And one of the biggest factors currently with regard to staying in school for some is the expense. And it's different if you're self-financing and you lose your job, or you have a reduction in hours and pay, versus students that are more fortunate and are able to rely on student loans. So to compare our retention rate, registered schools, apples to apples with the CALs or the ABA schools, I think is fundamentally flawed if you don't take into consideration the nature of our enrollment and find out what's the distinction in percentages between self-financing students in a registered program versus a CALS or an ABA. So I don't know if anybody's ever thought about doing that, but that would be, I hope, one point that the folks that we talk to would finalize and report back to the committee. So hopefully giving you a heads up and a preview of coming attractions.
Thanks, Dean Leal. And that's part of the reason why that particular focus group was broken up into 3 segments: the registered, the accredited, and the ABA schools, to allow a little bit more time for those category specific insights. So I want to thank you both for participating. And also, if your school has already participated in one of the prior 3, each of the focus groups deals with a different aspect of retention. So you're welcome and encouraged to attend more than once. So just a quick reminder, you can send an email to lawschoolregulation@calbar.ca.gov. And you'll be sent the Zoom link in order to have your representative attend. Any questions about focus groups before I move on to my final announcement?
I have one. I'm
Sure.
looking for the raised hand. If you don't mind, I'll not
No
do that.
problem.
I'll just ask. What is the topic for the upcoming focus group? Do you know?
Mentorship is a main element. This is the all of the other topics that were discussed on the survey that haven't yet been discussed, but mentorship is a key element.
All right, thank you.
Yeah. And then finally, Dean Liu.
My bad, I'm sorry.
Thank you.
I forgot you got to lower your hand, sorry.
Okay, no problem. And then most of the resources we've talked about today are directly for the law schools, but this final one is for the law students. Just to remind you that in March, there will be a state bar day coming up for law students. It will be a webinar presentation where students can log on and hear from people in the various departments in the state bar, trial counsel, the lawyer assistance program, the Office of Admissions, and in particular, moral character. Students will be getting that application invitation directly to register for the Zoom webinar, but we will also let the law school deans know as well. So that's coming up in March. Okay, and so that's all we have for recent developments. And Dean Frickberg, when you're ready, we can proceed to the discussion item.
Thank you. And our last agenda item E is a discussion for unaccredited guideline 1.11. Natalie, would you like to talk to us about that first before we start discussion?
Sure, and I'll ask Raquel to get ready the item that will be shown at the CBE agenda on Friday, turning to the portion that has the track changes motion. So just to get everyone on the same page as far as the history, the Committee of Bar Examiners passed a waiver some time ago in 2009. A temporary waiver generally does not continue for that amount of time, but at that time, the purpose of the waiver was to waive guideline 1.11 for unaccredited law schools. That guideline is a guideline that discusses parameters and prevents unaccredited law schools from offering state bar exam prep classes for credit. With the waiver in place, it is possible to do so. Schools are asked to mention that in their annual reports, and the committee has decided to take this up to refresh everyone as to the waiver and to determine whether at future meetings the actual text of the waiver will be discussed and possibly an amendment proposed to bring back to the CBE later this year. And Raquel, if you wouldn't mind sharing your screen so we can see the actual item itself. It's item 402 on the CBE's agenda.
Are you able to see my screen?
Yes.
Okay.
Thank you. So you can see the text of the actual guideline right now. There is a tentative waiver language that's proposed by staff that is just for a discussion starter. The purpose at this point is just for the CBE to introduce the discussion and to bring this guideline back to CSBARS for a discussion most likely in March and April, depending on what the CBE concludes. And I'm not sure if our CBE member, Paul Kramer, would like to add a comment or two.
Yeah, the way staff has approached this is on the assumption that we simply didn't get around to making the formal amendment to the guideline. But I, for one, feel it's appropriate to revisit the appropriateness of allowing review courses to be part of the credit requirements for the JD. Mostly because I'm concerned that it reduces the amount of and the potential breadth of a law student's education if instead of taking additional electives to fill those last hours, they are simply preparing themselves for the bar exam. I don't believe ABA schools allow this. We do currently allow it for accredited schools, and I would guess that if after reviewing the pros and cons of such an approach, if we determine that it wasn't appropriate, then ultimately that permission might be withdrawn from the accredited schools as well. At this point, I have questions. I haven't made up my mind in any way, but this waiver basically has, as far as I can tell from speaking to Natalie, no legislative history. So nobody can really explain why we were doing this in the first instance. So my message is, I'm expecting and hoping for a full discussion of this, the merits and the appropriateness of this this approach today, not simply a ministerial formal implementation in our guidelines on the assumption that it or assuming that it was a good idea in 2009 without knowing why we thought it was a good idea, why our predecessors thought. And as far as I understand it, that even includes, this was before George's time as bar staff. So in the interest of full disclosure, just want to make sure everyone understands that that is my recommended approach to this for the committee. And I'll be telling them that on Friday.
Dean Keller has raised her hand.
Just a point of information, if I heard Mr. Kramer correctly, he was saying he did not think the ABA allows this. The ABA definitely allows this. They changed their rules some years ago so that students could earn credit for bar prep and therefore increase their success on the bar exam.
Oh, okay. I'm kind of surprised because, well, I consider a well-rounded lawyer. I see some of the curriculum that, you know, some of our California schools have, and there really aren't a lot of electives, and maybe that's okay. But I hope we're not drifting to a world in which we're simply, on the one hand, some people are trying to get rid of the test, but everybody's focusing on just teaching students to pass the exam at the expense of creating lawyers who are well-rounded in the various aspects of the law that are not tested on the bar exam, and you know, are narrowly focused to an extent that it will compromise their ability to adequately represent clients.
Mr. Murphy?
Yeah, Ms. Keller beat me to it, but it is true that at one time the ABA accreditation standards forbade course credit for bar review courses, but it's actually during my time on the council that rule was removed, and the pressure, as I recall, came primarily from schools that are in the lower rankings in the U.S. News and World Report tiers, and their view was that they wanted to try to do their best to get people through the bar examination, and why not allow it? I understand Paul's comments on that and the rationale for it, but in that rule went by the wayside, and I delayed raising my hand because I wanted to go back and look at the standards, and it would have been in 300s, and I looked, I can't find the prohibition against credits in the standards anymore. So
is there some kind of limit in the amount of credit?
No, I don't think there is, Paul. I'm not warranting that because I didn't do a thorough study, but I went through it, you know, looking for where it would be. And but I'll do this. I promise I will double check it, and I'll send out the information when I find when I'm confident my memory is correct and my review of the current standards is correct.
So in theory, then somebody might be able to create a law school curriculum that included only the bar tested subjects and 20 units maybe of bar prep, and that might meet the standard.
You know, I think that that might run afoul of other standards regarding the curriculum. Let me just check here. Understand I haven't been in the depths of these for 3 or 4 years now, so my my precise memory is not as good as it used to be, but I think generally you're probably right. I think that that would probably raise some concerns with the accreditation committee, and they'd be looking for some limitation on that.
Yeah, so I'm of the mind that at a minimum, we need to set limits. Natalie, did you tell me recently in the accredited rules, there's I don't know if it's a reasonableness standard, but it suggests that it should be a minimum amount of credit for this sort of activity?
Historically, the accredited rules allowed these classes for credit, and it said that the credit should be kept to a minimum. For most schools, that was generally 1 credit. As part of the move to the new accredited rules that are less prescriptive, that limit was removed, and we'll be seeing how the schools react to that.
Okay.
You know, just to follow up, standard 303 of the ABA rules is one that generally governs curriculum, and it says a school shall offer a curriculum that requires each student to satisfactorily complete at least the following: 1 course, at least 2 credit hours in professional responsibility, 1 writing experience in the first year, and at least 1 additional writing experience after the first year, and 1 or more experiential courses. And then you have to also provide opportunities for law clinics and field placements, and then participation in pro bono legal services. So that's the prescriptive element of what has to be included, but I don't find any prohibition against or any limit on the amount that could be given to credit given for bar review courses.
So then
bar preparation.
So then they could theoretically leave out something like torts. I mean, they'd be crazy to do that because they know that all the state bars test on that, but it's not literally a requirement.
Yeah, I think that there's always been the general, it's almost a tradition. There's that first year canon towards contracts, you know, criminal procedure, real property and the like. All the courses are typically on the bar examination. So it's hard to imagine a law school that wouldn't include a course in torts and just wrap it into a general bar review course. But I never saw anybody even come close to proposing that.
No, that would be nuts.
It would be, and I just don't think you'll see it happen. But anyway, we're talking about what the standard says, and I just don't. That there used to be a standard, but it was removed during I believe it was during my time on the council. And frankly, I don't recall exactly how I voted on that. I might have been very well posted at the time, for the reasons you've articulated, Paul.
Thank you. I also like to point out at this time, again, from our recently adopted accredited rules, Rule 4.160C, again, one of our 4 pillars of accreditation here in California that we all agreed on, preparation for licensure and professionalism. I think this would definitely fall under preparation for a licensure as it is a licensure exam. Also just some backstory on the accredited side. I remember when CALs were prohibited from doing this as well. And many of the CALs at that time, rather than having a bar review, had a legal writing course. And it came under the euphemism of legal writing rather than bar review in of itself. So sometimes it became more branding than form over substance as you go through. Dean Leal, you have your hand up?
I do. Thanks, Dean Frickberg. Yeah, I want to make a few points and for purposes of discussion at this level, and then more importantly to the committee, because I think the committee honestly should take a good, long, hard, but a fair look at what's being proposed. And a couple points that have already been made, I'll emphasize, is after a lot of discussion and hard work among people who know what they're doing, it was decided and voted and adopted by the committee to take any limitation out of the CAL's rules as to how many units that a bar exam prep course could be required. And to go backwards in terms of unaccredited registered schools and impose limits, I think is very short-sighted and honestly extremely counterproductive. I would encourage Paul, you and everyone on the committee to understand the fundamental sea change that has gone on at the ABA level and look at, and I know for a fact because I've taught at the USF's school in their legal writing course, and I'm aware of what they now and how they've adjusted their curriculum with regard to courses specifically designed to assist students to pass the bar exam with good results. Their bar pass rate has gone up. So at the ABA level, and discussions about what the ABA schools, I think, is marginally relevant to what we do in our world. It's a guidepost, perhaps at best, and as it's been mentioned by Mr. Murphy, they've taken the wise view that limits on bar prep is not a deterrent to a sound legal education. And getting back into our world, my world, the registered schools, it's a very short-sighted opinion to think that somehow, and honestly, and not to be too pejorative, it's a implicit bias that any of the schools governed or regulated by the Committee of Bar Examiners would take the kind of attitude that you've expressed, that somehow we would be able or willing to shortchange our students to provide them with what we're required to do under Unaccredited Rule 5.1, a qualitatively and quantitatively sound program of legal education. So to teach, a glorified Barbary review session and call it, a sound and qualitatively sound is absurd. Now, in our world, to my point, we have the incredibly difficult challenge of getting our students to pass the first year exam. And so providing them, as I have since I've become dean at my school, with a comprehensive review session that initially we didn't provide credit, then it was 2 units, and now it's 3. And it's 3 units because it probably exceeds by a third. 3 units of credit in our program is 45 hours of class. Our students, probably with a full day mock exam, are spending 60 to 70 hours in our review session. And so it's well worth 3 units. And not at any detriment to the rest of the curriculum. So another point to make is, and again, success speaks for itself. 2 of the most recently accredited CALs, Concord and St. Francis, have for many years provided under this waiver credit for bar prep and first year prep. And it worked. They're accredited. That's our goal. And so putting limits on any express limits, I think, is, again, counterproductive. If you want to talk about equity and inclusion, help schools like mine get more students to pass the first year exam and then be better able to pass the bar exam. So, to the extent that we all want the same thing, competent and ethical lawyers practicing, providing the kind of assistance that the ABA, CALs, and our schools have for some time, I think is the way to go. So I'm happy to have that discussion here later or in front of the committee. So I hope the committee will take a very holistic and forward-thinking view of what this means to my school and any other school that would choose to go in that direction. So thank you for your time, and I appreciate listening.
Dean Park.
Thank you also for that time. I think Dean Neal said it well, that I think there's a lot of value to take a holistic and forward-thinking perspective on this topic. I had 2 points. One that goes to what kind of input I think this committee should be giving, and the second one just more from a stakeholder perspective. So in the first point, and I think just in terms of guideline development or rule development, what I've really seen in the process for the new accredited law school rules is, if we're going to be creating good rules and guidance, not trying to use the task of what we're doing to target what might be improbable, or there might not even be data there to show those kind of issues. Really, the guidance can be, or the language can be directed around how to, maybe it does go more towards curriculum or different areas, but I think there's a lot of ways to handle concerns rather than just doing so restrictively. Speaking as a stakeholder, so at a registered law school, online distance learning, with the continuous study rule in place and the bar exam requirements, I think there's a lot there to think about in my first point, that really the work of good rule development and guideline development is reflective on trying to make sure the rules and guidelines come from a good perspective on the data of what you're handling, which I don't think necessarily continuous study rule came out of. So I think there's just an opportunity to keep turning the page and make sure that the rule and guidance really comes from data study or things that are scenarios that schools are running into. And I'm sure that's coming up even with the great bar exam data studies being done at the state bar right now. To speak to this issue, ALU has never offered for academic credit a bar exam review class. So it's interesting to know about this. I'm really glad to see how this is highlighted. I believe, and I think I recall a 2009 file, but it was interesting to see this, realize how law schools are having ongoing waivers of this, because this was something as a stakeholder, you know, I would have loved to have known. So I think the work of trying to get clear and accessible language to stakeholders about, you know, the status of this, what are the options, and if it's a temporary waiver, what's the time limit with it? I definitely do encourage that. And that's the end to my comments.
Thank you, Mr. Murphy. I think you were next.
Thank you. And just to close the loop on the question of limitations with respect to bar review courses, standard of the ABA standard 311C provides a law school shall not permit a student to be enrolled at any time in coursework that exceeds 20% of the total credit hours required by that school for graduation. Paul had asked, is there a limitation? I suppose that would be one limitation.
Well, isn't that just a limitation on how hard they're working? In other words, don't load up a semester with too many classes. Is that what that's saying?
And a time, yeah, a law school should not permit a student to be enrolled at any time in coursework that exceeds 20% of the total credit hours required by that school for graduation. Yeah, I think you're right. That's the only limitation I could find on almost any kind in terms of on the credit question. Except for distance learning stuff, there's limitations on that.
Mr. Kramer, was there another point you wish to make?
Yeah, I was just going to say, Dean Park has highlighted another project I think the bar needs to work on, which is making all of our rules accessible to people. If you see the staff report for our meeting, it indicates that the waiver was mentioned in a written materials that were distributed in, I think it was approximately 2018, but it's not among the materials that are on our website. And so just to tell you, one of the things I'm going to be talking to staff about is how we can be, we can make it easier for people to find our current rules. And in the case of the accredited rules, the set that, is gradually transforming out of effect, but as we, we transition to the new rules. But that's a problem I have found on occasion. And, when you try to find something on the bar website, it can be more difficult than it needs to be. And this is an example where if Dean Park is, really internet savvy, she probably throws out the paper when she gets it because she doesn't want to have to mess up her counter there. And so she wouldn't know.
Just to speak to that, we definitely keep paper records and binders and such at our office. But yes, this is one of those where it would have been, and I see it now, which is great, but I definitely would have circulated with staff had it been presented differently in the past. So thank you.
Dean Clancy, you have your hand up.
Yes, I want to say that I agree with everything that Dean Park said and everything that Dean Leal said. But I'd like to add the fact that it seems to me that allowing credit for a course that focuses on bar review is very consistent with the state bar's emphasis on a minimum pass rate for each school. It just seems very consistent to me that that the bar would allow this type of course to take place as a part of the law school curriculum and credit to be granted for it. And I can say too that one reality that's occurred to me is that when you're teaching bar review, you're also teaching very important nuances in the law. So when you're teaching people how to pass the bar, you are teaching them the law. Thank you.
Definitely. Is there any further discussion from our group? Dean Leal, your hand went up and then no. Okay.
Dean
hearing no-
Frickberg, just a couple of helpful points regarding this. There were some questions regarding the status of the waiver, which is why it's coming back to the committee to make it a little bit more clear. And as a result, it seems possible that there are some schools that were using the waiver but didn't note so in their annual reports. So one thing we will be doing is we are in the process of doing a survey of the schools to find out who is using this waiver right now, and then getting that documentation that we need in order to bring back some data to the next meeting. And we also have received general questions about whether the guideline should treat differently review courses that are taught by outside parties versus taught internally by the school. No answer to that, just an additional point that would be raised. And it's also possible to encourage those watching and also CSBARS members to submit public comment to me or to the law school regulation box in the ensuing month as we prepare for future discussion at CSBARS to see the sort of issues that you raise so that we can have the data available for you to have a rich discussion at the March and April meetings.
Definitely.
Thank you.
Yeah. And I'd like to echo that as well, that again, those that have an interest, I'm sure we'll be more than welcome for public comment within the committee meeting that's going to take place this Friday, where this same issue will come up. That might be another mechanism that we can use now, as I'm sure this will be an ongoing issue for the next few months. Again, any chance for further discussion on this? We have 3 minutes left if there is an interesting discussion.
Actually, I wanted to, if I can, Jay, just to make a couple points. And the history, and it is, I'm a part of it, obviously. It's also unfortunate that, so the mistake I think was made, and I don't know if it was on my watch or whoever's watch, but what's on, I would argue that it's relatively easy to find the rules and guidelines, both for the CALs and the unaccredited schools on this PAPAR website. It's right there if you know where to go, and you click it on. The transcription from the hard copy, which I've got here, which I still use daily, left out the footnote that was put in, back in 2017 when this was revised to add in the rules the number of units that we have to, our schools now required to offer for, practical skills training. And I can attest and would sign an affidavit and declare in court, this was mailed to every registered school at that time. And so you're right to the point that comment made that people are not using the hard copy. And I know talking to a number of deans, they did what people do today. They downloaded the online version and had no idea. So maybe we can chalk it up to it fell through the cracks between those of us who still like paper and those who deal exclusively in the internet on the web. The last point is, it's a shame that it's taken this amount of time, 12 years, for the committee to circle back and finally take action on that. And my last comment would be, it's an unfortunate, and maybe this is no longer the case, I hope, that so much time and attention of the committee and staff has been focused over the last 10 years on the CALs, that the registered schools were pretty much left on the sidelines, and it didn't come. Years went by before this was actually, the unaccredited rules were reprinted and sent out. So hopefully those days are past and what's on the web is now accurate. And this important waiver, at least temporarily and hopefully permanent, will be better disseminated in all the schools and know that, that it exists and should have known for quite some time. Thanks again.
Again, final opportunity if there's any comments on our current agenda item E.
At this point, for future reference, the current copy of the rules should be that is up on the website. And depending on the committee's discussion and determination on Friday, any additional information as to this can be and will be added to the website. So some of the things that were sent out in the 2017 paper sets have been superseded. And of course, in the case of the unaccredited rules, the entire rule set. It will be our job to be sure that the correct information is easily available on the website. Duly noted, and thank you for that feedback.
So seeing no other hands, I think if we can entertain a motion to adjourn. We have no other agenda items that I'm aware of.
No other, Dean Frickberg.
So do we have a motion to adjourn?
So moved.
Do we have a second?
Second.
Seconded.
Thank you.
Thank you. That concludes our meeting.